This afternoon, Fulton County District Attorney Fonnie Willis published a letter responding to Republican Congressman Jim Jordan. He's now in the majority. He's now the chair of the Republican so-called weaponization committee, who has tried on multiple occasions now to run cover for Donald Trump by obstructing Willis's investigation. Willis writes, quote, Chairman Jordan, I tell people often, deal with reality or reality will deal with you. Face this reality, Chairman Jordan. The select group of defendants who you fret over in my jurisdiction are like every other defendant entitled to no worse or better treatment than any other American citizen. For a more thorough understanding of Georgia's statute, its application, and similar laws in other states, I encourage you to read RICO State by State. As a non-member of the bar, you can purchase a copy for $249. In addition to that letter to Jordan, Willis is taking new steps today to protect jurors from potentially violent Trump support. As we've covered on this program before, the trials of Trump and his 18 co-defendants in Atlanta will be televised, and not because it's a Trump trial, that's what happened. And that, to my mind, is a good thing. I mean, especially as voters consider whether or not the 4 times indicted ex-president should be sent back to the White House to finish the job he started on January 6th. That said, D.A. Willis is understandably concerned about the safety of those jurors sitting in that jury box that you see there over the attorney's right shoulder. Those jurors who will determine the fate of the ex-president and his confederates. In a legal motion, she asked Judge Scott McAfee to bar the press from publishing any information about the affected jurors, images, videos, or court statements. It's not an abstract concern. As D.A. Willis notes in the motion, personal information about the grand jurors who voted for the right now was shared online with the obvious intention of correct. Willis herself has been doxxed with a racist death threat as a result, and we know Donald Trump cultivates intimidation and menace as a routine part of his political agenda, as a tool to wield. In fact, part of the Georgia RICO indictment deals specifically with the harassment of 2 specific election workers who had angry Trump supporters showing up outside their home because their address got put on the internet. We may learn even more about that harassment tomorrow. That's when the special grand jury report outlining Trump and his co-defendants' alleged crimes is made public in 10 minutes. That's not all we got out of Georgia today. Trump's lawyers say they may request to move his trial to federal court. And then speaking to federal court, after a month-long break, get this was surprising when I saw this today, and I still don't know quite what that means. We're going to try to find out. But Jackson's federal grand jury, the one that's looking into the attempted coup, the one that indicted Donald Trump a few months ago, met again today to continue its investigation. There is no indication that things are slowing down anytime soon. Doris Cordell served for 19 years as a judge, including over a dozen Superior Court of California. She's author of Her Honor, My Life on the Bench. Harry Whitman served as Deputy Assistant Attorney General of the U.S. Department of Justice. He's now a legal affairs columnist for Judge Cordell, let me start with you on this juror question. I read what District Attorney Willis had to say. It seems eminently reasonable. I wonder how much is this standard practice in a high-profile case? How much is this a sort of extra prophylactic measure given the context of what we've seen before, and particularly Trump supporters?
Chris, the first anonymous jury in this country was encountered in 1977 in New York City. It was a trial of Leroy Barnes. He was a drug kingpin. And it was an anonymous jury because his network was such that they were concerned about jury tampering, intimidation, violence. This man was charged with all manner of drug crimes as well as a number of murders. So that's where we have an anonymous jury. That's where it started. And it became very common in the 1990s. A more recent high-profile case was the case of Joe Zimmerman, who was charged with the murder of Trayvon Martin. That was an anonymous jury, again, because of concerns. There were protests going on. So to have an anonymous jury in the case in Fulton County, it's not only appropriate, should be required. We know that. We know what's going to happen. What's going to happen is what happened to the grand jurors whose personal information got out. So we already know what's going to happen. I think the judge is required to do it. And I do want to note that in the Trayvon Martin trial, the trial of George Zimmerman, the jury was actually sequestered during the deliberations. And I think it's highly likely that that's going to happen in the case of
they're saying they might do it. It seems to me, and again, I don't, the procedure here is complex and opaque, and I don't, it seems to me that what's in their interest is to burn as many days as possible and wait until the last minute to file that, so you can push out the deadline of that, and everything has to go on and on. Is there some drop-dead date that they have to say whether they're going to do that or not, or can they just burn up time until they're forced to?
There's a drop-dead date. It's 30 days after it's been arraigned, which was August 31st, so it's September 30th. But I think we've always known that it's going to go to the very end, just as you say. Any hour out of the way is a good hour for Trump. So it's a foregone conclusion, I think. And, we said this up front. We would do it. We would do it at the end of 30 days. His prospects are very, very poor. It's of a piece with what's going on with Mark Meadows, what happened with Trump previously about trying to show executive privilege. That is he in the conduct alleged acting within the scope of his official duties as president. And, so making a coup is nowhere in Article 2. I think they will make quick work of it. They'll be able, these motions provide for automatic right of appeal, so it'll go up to the 11th Circuit, but we have to hope that they'll make quick work of it. But remember, Judge McAfee talked about that even at the hearing as perhaps a matter of months. So that's something he's been planning on burning from the start, starting with his first 30 days.
Yeah, and I gotta say, again, from my perspective, Meadows even has a more plausible claim to me if he's saying I was subordinate, I'm the chief of staff, I do this, than the guy who's actually engineering the whole thing, who obviously can almost by definition be acting with capacity to undo an American election.
100%. Meadows is the only guy who has, I think, a colorable claim. The other three who are trying Georgia electors will have said sort of very punctually they were just masquerading. Anyway, there's no federal role they have when they're showing a fake marshal's badge. And so I think it's Meadows and Meadows only, and then the question of who goes over with him. That's an unsettled question in Georgia law. Yeah, but I think Trump is DOA, but of course he'll do it and play out the appeal, probably petition for cert even. But this is a claim that I think it goes nowhere.